Hello friends, I'm Sanjay. This is part 9 of the series in which I'm covering the interpretation of statutes and the principles of legislation as per the standard LLB syllabus. The playlist for this complete series is available on the Lawment YouTube channel. In this part, I will be covering some of the important features of the General Clauses Act of 1897. This is a fairly short act, just 14 pages in total, and if you remove the index, the references and the blank spaces, it is just around 10 pages. I recommend that you should read the bare act when you have the time. In this video, I will give you an overview of some of the important aspects of this act. The General Clauses Act is from the year 1897, which makes this more than 125 years old. So the question now is whether this act is still relevant after all these years. Well, the Constitution of India says that the General Clauses Act should be used for interpreting the Constitution and other acts made when India was a dominion of the British. And several current statutes, including recent ones like the Bharatiya Nyaya Sanhita, the Bharatiya Suraksha Sanhita and the Bharatiya Sakshya Adhiniyam, continue to have references to different sections of the General Clauses Act. So, is the GCA still relevant after more than 125 years? The answer is yes, it is still relevant. How is the General Clauses Act actually used? Let's look at this scenario where there are several statutes that use the term regulation. Now, the meaning of the term regulation has to be same in all of these statutes. It cannot have a different meaning in different laws. To ensure that a common standard is followed, all of these statutes may include the clarification or the reference that the meaning of the word regulation is as defined in the GCA. And section 50 of the GCA gives a definition for the term regulation, which is applicable to all of these statutes. Tomorrow, if a new statute is passed called the Bharatiya Regulation Act, and you now have to amend the definition of the term in all of these statutes, you don't have to pass so many amendment acts. You just have to amend the GCA. By providing one common reference source for the definitions of various terms, the GCA not only shortens the text and the language of central acts, it also provides a uniformity in the terms used across different acts and regulations. And as we will see later in this video, the GCA also provides some standard rules for the construction and interpretation of central acts. For example, several acts talk about different actions to be taken within 30 days, and the GCA provides clarity on how that 30-day period is to be calculated. Where are the definitions in the General Clauses Act applicable? The Act itself provides clarity on the application of the definitions. Section 3 says that the definitions given in the GCA are applicable on all central acts and regulations which were enacted after the GCA was enacted. Section 4 has a list of certain specific definitions which are applicable on acts and regulations that were enacted before the GCA was enacted. So there is some retrospective effect to the Act. Section 4A specifies the definitions that are applicable on all Indian acts, both central acts and state acts that were enacted after independence. You will also see that all of these provisions have the exception that these definitions are applicable unless there is anything repugnant in the subject or context. This means if you want to have a different definition for a term in a specific act, you can do so, and the definition in that act will override the general definition in the GCA. When is the General Clauses Act not applicable? For example, the definition of the term document is given in the GCA, and this definition is applicable wherever this term is used in other central statutes and regulations. But some statutes may specifically define the term within themselves. For example, the Bharatiya Sakshya Adhiniyam provides its own definition of the term document. So the GCA definition will not be applicable here. We can say that the definition is self-contained within the Sakshya Adhiniyam. In other situations, a statute may specifically refer to another statute for definitions. For example, the Sakshya Adhiniyam says that for any words and expressions used here, that is, in the Sakshya Adhiniyam, which are not defined in the Adhiniyam itself, the definitions in the Information Technology Act, that is the IT Act, the Suraksha Sanhita and the Nyaya Sanhita will be applicable. In this situation, the GCA definitions will not be applicable for any terms already defined in these other statutes. To summarize the flow, when a term is used in a statute, first check if the term is defined in the statute itself. If not, check if there is a reference to any other specific statute. If the answer is no for both of these, then the GCA definition will apply. Let us now look at how the General Clauses Act is structured. As we have already discussed, the GCA was enacted to provide a single statute containing the common definitions, the common interpretations, and the common legal principles that are applicable across various central statutes, laws, rules, and regulations. To a certain extent, the GCA becomes a part of and affects almost every central legislation enacted after the GCA was enacted in 1897. And unless the law is self-contained or there is a reference to some other statute, the GCA definitions are applicable to all central acts and regulations, unless this leads to some repugnancy or a clash or a contradiction in the subject or the context. The GCA itself is a fairly short statute. The preliminaries are covered in Section 1. The general definitions are provided under Sections 3 to 4A. The general rules for construction of statutes are covered under Sections 5 to 13. Various powers and functionaries are covered from Sections 14 to 19. Provisions as to orders, rules, etc. made under enactments are covered under Sections 20 to 24. And Sections 25 to 30 cover miscellaneous topics. While I will cover some of the important sections from all of these different parts, I will encourage you to just go through the bare Act at least once, especially since this is a very short 14-page statute from end to end. Section 3 of the General Clauses Act is the most extensive section of the statute. It extends to almost 6 pages, which is a little more than 50% of the actual contents of this Act. There are more than 60 definitions under the subsections of Section 3. I will not go through all of them here because they are just simple definitions and you should read them in the bare Act itself. As I have mentioned previously, in all central acts and regulations enacted after 1897, these definitions from the GCA will be applicable, unless of course the Act specifies a different definition in itself, or the Act refers to another Act for the definition, or if using the GCA definitions of the term leads to some repugnancy with the subject or the context where the term is used. Section 5 of the General Clauses Act provides clarity on when a central act comes into effect or commences operation. There are two aspects here. What is the day or the date when the act commences, and from what time of that particular day or date does it come into action? When we read the first part of this section, it is essentially stating that the date of commencement of an act will be mentioned within the act itself. For example, the Income Tax Act clearly states that it comes into force from the 1st of April of 1962. Or the commencement date of the act can be published when the act itself is published in the official gazette. Or the central government may specify the commencement date at any time by publishing a notification in the gazette. Like this Nyaya Sanhita says that the commencement date will be published in the future, and this commencement date can be for the entire act or even for specific provisions or specific sections. If there is nothing mentioned about its commencement in the act itself or in the gazette notification, the act is deemed to be in force from the date when it received the assent from the President. Now that we know how the day or the date of an act coming into force is determined, subsection 3 of section 5 clarifies on the time of the day when the act comes into force. It essentially says that the act comes into force from 0000 hours of the day, that is immediately on the end of the preceding day or the previous day. Section 6 of the General Clauses Act covers the repeal of a central statute or regulation. What this section actually says is that when a central act or a regulation is repealed, it does not automatically revive any previous law. That is, when the Finance Act of 2023 is repealed, it will not automatically revive the Finance Act of 2022. Any operation of the law before it was repealed will not be affected, which means that any previous rights or liabilities that were created when the law was in force will not be affected. Any penalties or punishments under the law when it was in force will not be affected. Any previous actions initiated when the law was in force, such as investigations, legal proceedings, or remedies, will continue as if the law was not repealed at all. Only new investigations or legal proceedings cannot be initiated using the repealed law. Section 9 of the General Clauses Act talks about the commencement and the termination of time as mentioned in different acts. It clarifies how to interpret the words from and to when they are used in reference to time. For example, the Companies Act says that the dividend should be paid within 30 days from the date of declaration. And if the date of declaration is the 31st of December, the window starts from the 1st of January, which means that the first in the series, that is the 31st of December, when the dividend was declared, is not included in the window. So the deadline for paying the dividend is until the end of the day on the 30th of January. Similarly, if a statute says that a person has time up to 30 days to do something, the implication of the term to is that the last day is also included, which means that there is time till the end of the day on the last day. Section 10 talks about the computation of time. We have already discussed how Section 9 covers the commencement and the termination of time. Section 10 just clarifies on what happens if the last day of that period happens to be a holiday. For example, a person is required to submit a document to the court or to a government office within 30 days from the date of an order. As per Section 9, the first day in the series is excluded. That is, if the order was issued on the 31st of December, that day is excluded and the 30-day time period starts from the 1st of January. So the 30th day happens to fall on the 30th of January. However, 30th January was a Sunday or it was a holiday and the court or the office was closed. Section 10 clarifies that in such a situation, the document can be submitted on the next day, that is on the 31st of January. Remember, this extension is applicable only if the last day of a period happens to be a holiday. There are no extensions for any other holidays or closures on any other days in the submission period. Section 11 of the General Clauses Act talks about how distances will be measured in any central acts or regulations. It says that unless a different intention is specified, distances shall be measured in a straight line on a horizontal plane. Why is this important? What is the relevance of measuring along a horizontal plane? Suppose I have some land that measures 200 feet in length from this point. And suppose the land has a small hill on it. If I measure 200 feet along the surface of the land, you will see that my house is not in my land at all. However, if I measure 200 feet along the horizontal plane, then my house is actually within my land. Since the surface of the land is covered by hills and valleys and other features, there can be confusions around how do we measure distances. To ensure standardization across all laws and regulations, the General Clauses Act says that distances shall be measured along the horizontal plane only. Section 12 of the General Clauses Act talks about the pro-rata application of any duties to be paid, such as customs or excise, which may be levied on the basis of a quantity, such as weight, measure, or value. This again is common sense, because if the duty to be paid on a 100 kg bag of rice is 100 rupees, then the pro-rata duty on a 25 kg bag will be 25 rupees and the pro-rata duty on a 200 kg bag will be 200 rupees. Another example could be that a particular annual tax is introduced on companies during the middle of the financial year. Then the tax will be payable on a pro-rata basis for that financial year. For example, if a tax was levied at 12,000 rupees per year and it was introduced in September and payable from October onwards, then the number of months remaining in that financial year are 6, that is October to March. Therefore, the tax payable will be pro rata for 6 months for that year, that is 6,000 rupees. For the next year, because we are talking about a full financial year, then the full 12,000 rupees will be payable. Section 13 of the General Clauses Act clarifies that in any central act or regulation, unless there is some repugnancy with the subject or the context, words importing masculine gender will be taken to include both males and females. In most statutes, only masculine gender is used, like he, his, or him, and only a singular is used. This doesn't mean that the law is applicable only on males and that too only on one person. So this he should be read as he or she, and he or she actually implies they, that is in plural. So this law will be applicable on both males and females and also on any number of people who are covered under that law. Of course, the repugnancy will be in situations where a law is gender specific. That is, if the law is specifically supposed to cover only men or only women, then he means only a male and she will imply only a female. Section 14 of the General Clauses Act clarifies that unless there is a different intention, the powers conferred by any central act or regulation can be exercised from time to time as required. For example, the Central Board of Revenue Act confers certain powers on the Central Board of Direct Taxes, that is the CBDT. By default, these powers can be exercised by the CBDT whenever required and not just for one time. If there are any specific powers that can be exercised one time only, then the Act should clearly specify the same. Otherwise, the powers are deemed to be exercisable whenever required. Section 15 of the General Clauses Act talks about the concept of ex officio appointments. Ex officio is a Latin term that means by virtue of the office or by virtue of the position. For example, the Chancellor of the universities in a state is an ex officio position and it is directly linked to the office of the Governor of the state. Any person who holds the office of the Governor of the state will also become the Chancellor of all the universities of the state. So this is a ex officio appointment. Section 16 clarifies that the powers to appoint will also include the powers to suspend or dismiss. For example, if an authority appoints a person into a particular role, the same authority will also have the power to suspend or dismiss the person, subject to certain conditions, rules, and regulations. Section 17 of the General Clauses Act says that when a statute is assigning any functions of an office to any person or a set of persons, it is sufficient to mention the official title of the officer who is presently executing the functions or who commonly executes such functions. For example, an act can specify that certain functions will be executed by the magistrate of an area. This means that any person who is designated as a magistrate of that area can execute the function, and there is no need to specifically name any persons. In short, functions can be assigned to offices or positions, and whoever holds those offices or positions can execute those functions. Section 18 addresses the concept of successors. For example, there are certain functions that were assigned to a commissioner of sales tax. That designation was replaced with Commissioner of Goods and Services Tax, which means that the functions assigned to the previous office are automatically transferred to the successor office. Similarly, previously there were state electricity boards which were succeeded by the state electric supply or distribution companies. So the functions of the previous organizations automatically transition to the successor organizations. Section 19 talks about official chiefs and subordinates. If, suppose the post of a chief conservator of forests is vacant in a particular state and the assistant conservator is currently performing the functions of the CCF, then the ACF will have the authority that would be normally available to the CCF. In other words, a law applicable on the chief or the superior of an office shall apply to the deputies or the subordinates who are lawfully performing the duties of that office in place of their superior. Section 20 of the General Clauses Act talks about the construction of orders, rules, bylaws, etc., which have been issued under the powers granted by a central act or regulation. It simply says that the definitions or the meanings of any expressions in the orders, rules, bylaws, etc. will be the same as what they are in the act or regulation that grants the powers to make the order, rules, or bylaws. For example, the Central Board of Revenue Act confers onto the CBDT some powers to issue orders or make rules on income tax. And the CBDT accordingly makes some rules. Now, the meaning of the term income tax as used in these rules has to be the same as what it means in the Empowering Act, that is the CBR Act. The subordinate laws or rules cannot change the definition of the terms to expand or narrow their scope. The scope of income tax as defined in the Empowering Act will be applicable on the rules that are made under the powers conferred by such an Empowering Act. When you read sections 21 and 22 of the General Clauses Act, they sound a little complicated, but both of these are very simple and logical. Section 21 says that if an act confers the powers to issue notifications, orders, rules or bylaws, then such a power will include the power to add to amend, to vary or to rescind such notifications, orders, rules or bylaws. In simpler words, if you have the power to issue an order, then you also have the power to change that order or to rescind the order. Section 22 says that if a central act or regulation confers the powers on some office or some organization to make some rules, orders or bylaws, then these powers can be exercised by that organization, by that office or by that person at any time. But such rules or orders or bylaws will become effective only when the main statute becomes effective. For example, if the Bharatiya Nyaya Sanhita has been approved by the Parliament, passed by the Parliament, but it has not been notified as being effective by the government. But the Nyaya Sanhita gives me some powers to make some rules. So I can exercise those powers and make the rules at any time. But those rules will come into effect only when the Nyaya Sanhita itself comes into effect. That is, if the main law itself will commence from a future date, then the rules or the orders made under such laws will also become effective on or after some future date. Section 23 talks about the scenario where an act or a regulation grants the power to make some rules or bylaws, but stipulates that they can be enforced only after previous publication. So it elaborates on how these draft rules or bylaws will be published, that any objections or suggestions on the draft must be taken into consideration, and then the final version should be published in the official gazette. Section 24 of the General Clauses Act talks about the continuation of orders, schemes, rules, forms and bylaws issued under enactments which have been repealed and re-enacted. A simple example of what this section is actually saying is this. The Finance Act is an annual statute that is repealed and re-enacted every year in the budget session of the Parliament. Since the statute is repealed every year, what happens to the orders, rules and bylaws that were issued under the repealed statute when it was still in force? Well, this section clarifies that they will continue to be valid and active indefinitely, unless the new statute, which has now been re-enacted, has some provisions to change or to rescind the orders, rules, etc. that were issued under the previous act. Section 25 of the General Clauses Act says that if any fines have been levied under any act, regulation, rule or bylaw, then sections 63 to 70 of the Indian Penal Code and the provisions of the Code of Criminal Procedure will be applicable on the issue and execution of any warrants in connection with the fines, unless of course the acts, rules or regulations under which the fines have been levied specify a different process. Just remember that the references here to the IPC and the CRPC should be interpreted as references to the successor acts, that is, the Nyaya Sanhita and the Suraksha Sanhita. Section 26 says that if an act or an omission is an offence under two different acts, then the offender can be prosecuted and punished under either or all such acts. However, a person cannot be punished twice for the same offence. For example, a person creates some fake documents to evade taxes. This can be two different offences. One is fraud or forgery, and the other is evasion of taxes. So the person can be prosecuted and punished under two different laws because the person's actions constitute two different offences. But if the action is defined as the same offence under two different statutes, then the person can be punished only once. And section 27 talks about the concept of serving by post, because various statutes may require documents to be served by post. In simple words, this section says that if a document, such as a letter or an envelope containing the document, is properly addressed, the postage is prepaid, that is, proper stamps are attached or the postage is paid at the post office, and the letter or the envelope is sent by registered post, then the letter or the document will be considered as being served at the time when the letter would be normally delivered by the post office. This means that the person being served cannot escape by saying that I was not at home, I did not receive the letter, it was misplaced, my dog ate it, etc. As long as the sender has followed the proper process, then the document is deemed to have been served. With that, we have covered all the important aspects of the General Clauses Act. If you have any questions or feedback, post a comment below. We will meet again in the next part of this series. Jai Hind.